Good morning, everyone. Here we are 12 hours later after our public hearing. And welcome the public who's watching us today. This is the last meeting we have before the bill drop deadline of tomorrow at 5 p.m. in the House. And it's our intention to vote on every single bill that we have on our agenda today. We're going to start with the Legislative Bond Initiatives Training Facility at Central Maryland Research Education Center in Clarksville. Do we have a motion on that bill?
I move to support this bill.
Second.
So, Delegate Chow, just say you move approval of the bill.
Yeah, I move the bill.
Second. Barry seconded it. Delegate Hill. Would you please take the vote?
Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazzoni,
Yes.
Senator Hester, Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb-Gazzoni,
Yes.
Delegate Hill,
Yes.
Delegate Tarasa,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
Motion passes.
Thank you. Next up is Howard County Public Campaign Financing Board of Education 14-23. Senator Lamb, did you want to say anything about this bill?
Sure. Happy to explain where we are with this bill right now. Abby, is it possible to share my screen? I know there's a one-pager that we had circulated kind of summarizing an amendment that we've been working on to the version of the bill. And I just want to be able to, all right, so I will share this here. I think most of you, I think we've emailed this around to the delegation. Most of you have probably already seen this or had a chance to look at this. This is based on feedback that we received over the last week to be able to account for where members were with their input. What this revised version does, we will be offering an amendment to this bill. What this means is that for, we are still trying to phase in the public financing availability for Board of Ed candidates to run. We're also trying to better distribute the races so that the impact to the Citizens Election Fund is more distributed evenly through the election cycles. And so 2024, where there is no public financing available because it's next year, begins the process of phasing this in. What it does is that there are 5 council-based districts that are up for election. And the 5 candidates, the top 2 highest winning percentage candidates in their races will have 6-year terms. The other remaining 3 council-based seats will get 4-year terms. So that will separate the council-based seats into 2 groups, one 6 years, one 4 years. Then the next election cycle, this is to give time for the county, 1, to authorize this on the county level, and also 2, to put funds into the Citizens Election Fund to be able to support the additional candidates that would be supported by public financing in 2026. This will be the first year where public financing is available. It would be available for 2 candidates. This helps phase it in terms of number of available candidates that will be able to qualify or be eligible. So this would be available for the 2 at-large seats that are due up in 2026. The top vote getter would get a 6-year term. The second vote getter would get a 4-year term. And then the next election cycle in 2028, it would increase it to be available for 3 candidates. These are the 3 council-based seats that had 4-year terms determined back in 2024. So they would be available, they would be able to access those funds in 2030, which is the third election cycle where public financing will be available, also available for 3 candidates. The 2 council-based seats that had 6-year terms starting in 2024, as well as the 1 at-large seat that had a 4-year term beginning in 2026. And then subsequently after that, it would be available for all candidates in running for Board of Ed in the subsequent election cycles. So the intention here is that nobody's term is cut short. Everyone will at least have a 4-year term, in order to help with staggering and phasing this in, there are some folks that will have extended terms, 6-year terms based on performance in their elections. And this helps phase in public financing. And by 2030, actually, this opens up public financing beginning 2026. And then by 2030, it'll be available for all the Board of Ed candidates, and it phases in between 2026 and 2030. So that's our current proposal. There is an amendment, and I think we've circulated this amendment to all the delegation members. I want to thank our delegation counsel, Dara Moriarty, for really moving mountains to be able to get this amendment together in the past week as well. It got hung up in drafting, in review, and mostly because of the tie provision. So there had to be provisions in the event that there was a tie. What would happen in statute, there are actually provisions for ties where it would be drawn lots. Basically, you draw straws out of or you pick a name out of a hat. And so in the event of a tie, that's what happens as well. The amendments have been circulated by Dara. And Dara, anything else you want to add? Does the amendment match what I just went through?
Yes, I would, just to be terribly particular and technical. I would just say that the wording that we use now for this draw is a random drawing. It was previously used in the code elsewhere as drawing lots, but the terminology was updated to allow for more modern methods of essentially still drawing lots. So that's the only technical point I would make. Otherwise, substantively, everything you've said is
great.
Accurate.
Well, thank you again for all of your efforts in that. And so thanks for that clarification. Exceedingly unlikely that we would have a tie, but in the event there's a tie, that's what happens. So that's the explanation of the amendment. I move the amendment.
I'll second.
Can I ask a question?
Chair Watson, you're muted.
I'm so sorry. The amendment's moved by Senator Lamb. It's seconded by Ms. Ziegler. Is there a question?
Yeah, so if we don't adopt this amendment, what happens with that?
What happens with what?
Well, I guess I'm confused because we don't have an amendment in place, so I'm just making sure I understand what would happen. Like, this still would change when the elections are, in addition to the CEF piece?
Do you have the documents that we sent you on this, both the structure of the amendment and the amendment itself?
No, I don't have an amendment itself. I have the page that you dropped off.
So my understanding is if we do not adopt this amendment, the bill would revert back to what we discussed last week, where we had 2-year terms and we had predetermined order of districts. I believe Senator Delegate Feldmark made some very good suggestions along with Dr. Wu with regard to the terms and how we decide who gets the 6-year versus the 4-year term. And we changed all the 2-year terms so that there wouldn't be running for an office and only being in place for 2 years before you had to run again. The changes that are in the amendment were suggestions of the delegation, and that's where we are. Can we please take a vote on the motion? I mean, yes, on the amendment.
On the amendment, yeah.
Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Ghazzoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb-Ghazzoni,
Yes.
Delegate Hill,
Yes.
Delegate Terraza,
Thanks for the clarification on that. Sorry, I don't have it in front of me, but yes, I appreciate it.
Delegate Wu,
yes,
Delegate Ziegler.
Yes.
The amendment passes.
Do we have a motion on the bill?
I'll move the bill to a vote.
Second.
Second.
Okay. Any discussion? Please take the vote.
Senator
Take the
Lamb,
vote.
Yes.
Delegate Watson,
Yes.
Senator Ghazzoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
No.
Delegate Feldmark,
Yes.
Delegate Lamingazani,
Yes.
Delegate Hill,
Yes.
Delegate Terraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
Motion passes favorable with amendment.
Okay, that takes care of 1423. We're moving on to ranked choice voting, 1623. Dr. Wu, did you want to just briefly say anything more about that? There were no amendments since the last time.
Sure. Thank you, Chair Watson. Yeah, there's no amendment. This is just really try to enable the county council to support the ranked choice voting. And not only our county, many other counties are actually moving in the right direction. For example, Montgomery County delegation actually unanimously support their ranked choice voting as well. I think some other counties are moving in the same direction. I believe ranked choice voting will help us to really try to improve our election process and the results for the school board election. I hope like we get some support from the delegation and we can move forward.
Move the bill.
Second,
Discussion. Please take the roll.
Senator Lamb,
I'm going to vote no, and I just want to explain my vote briefly. I am concerned about the precedent when these bills have been brought up before for statewide discussion. They've generally not moved forward. So far, I don't think any counties actively have ranked choice voting, although there are some local municipalities that do. So I would like to give it further consideration later on, but at this point, I'm a no.
Delegate Watson,
Dr. Wu, I thank you for bringing this forward. I am not comfortable enough to vote on it this time, but I would like to discuss it more and work with you over the interim about the possibility of doing this in the future. My vote for now is no.
Senator Gazzoni,
I share the same sentiments that have been expressed, so no, at this time.
Senator Hester,
No.
Delegate Atterbury,
No.
Delegate Feldmark,
I know at this point, it's a bit of a symbolic move, but I do think this is an idea that we should be exploring and discussing further in the future, even if this bill isn't going to advance today, just as a show of support for continuing the conversation. I'm a yes.
Delegate Lamingazoni,
I'm going to be a no. I think we need to look at it a little bit more and
Delegate
want to look at it a little bit more.
sorry, Delegate Hill,
I echo Delegate Feldmark's comments. I'll vote yes.
Delegate Terraza,
Yes.
Delegate Wu,
yes.
Delegate Ziegler.
Yes.
The motion fails, lacking a majority in the Senate.
All right, moving on now to the archery hunting safety zone bill, Bill 15-23. Senator Hester, is there anything you'd like to add or say about your bill?
Thank you, Madam Chair. I would just like to say that I appreciate the prolonged conversation about the deer management issue. I am fully supportive of the amendment that Delegate Feldmark has, and so I would ask for her to introduce the amendment when appropriate.
Delegate Feldmark.
Thank you, Madam Chair, and thank you, Senator Hester, for this bill. I appreciate the concern regarding deer population, and I really appreciate all the time that you and your staff put into working with us to address safety concerns. The amendment I'm proposing, which I believe Dara has, or perhaps Abby has shared, is basically just narrowing this bill as introduced to 2 categories of bow hunting where the safety zone could be reduced down to 50 yards. And those 2 categories are for deer management permits, which is the state permit issued for crop damage for farms and orchards, or in a bow hunting program that is administered by the county. So, and we've had a lot of discussion with the county. I want to thank the Department of Recreation and Parks for all of their information and patience through the process. I do think our county has a strong program that is very focused on safety, with additional safety training and requirements and screening of hunters who participate. And I believe the county has the discretion to decide appropriately when to adjust down to 50 yards or something less than 150 yards. So those are the two categories where the safety zone could be reduced. And if the safety zone is, if the distance is anything less than 150 yards, it does specifically require that the bow hunting be from an elevated position with a downward trajectory. So I will move the amendment.
Second.
I do have a question, but first, are there any other questions?
Yeah,
Go ahead, Senator Gazzoni.
yeah. So with regard to the crop issue, how is that? I understand it's a determination by the state. How is that? Do you have any sort of any further information on how that would be administered? I mean, I guess my fundamental concern is that, on a couple acre lot, I don't want that to be thought of when somebody's having a garden in the backyard that's going to be considered crop in any way. Can you address that at all?
So it is my understanding, and I'm going to ask Mr. Moriarty maybe if he can help here with a little more detail, but it's my understanding that this is specifically for farms and orchards. I believe also for some forest, new forest growth protection, but I don't know the specifics of how the state regulates that or determines, but I do believe it is specifically focused on agricultural uses. Mr. Moriarty, can you offer any more specificity there?
Yeah, so I generally your assessment is correct. It's for the landowner or agricultural leasee of a farm, orchard, nursery, or a designated employee of the same. Applies to the Department of Natural Resources for this permit, which is issued in the case of sustained severe deer damage and economic loss to either commercial agricultural crops or in the cases of orchard or tree nurseries, orchard or nursery stock. I don't know, Senator Gazzoni, if that answers your question, or if you have further questions.
Thank you.
There is Delegate Hill with her hand up.
Thank you. And thank you for the amendment. It's certainly much better. So 2 quick questions. There was a lot of discussion about how elevated position is defined. So I want to know if the amendment addresses that. And then the second question is, I don't think we had this discussion before, but it won't hold anything up today. We went from 150 to 50. Was there any consideration, Delegate Feldmark, in your discussion with the county? Because I know in addition to the senator, you put a lot of time into this, about why that was the better number than say 100. In other words, why did we jump 2/3 as opposed to just going to 100?
Madam Chair, may I? So, I mean, from my perspective, it was really sort of that was the starting point, and that's the standard that is existing in other areas of the state. Again, I feel more comfortable with the provision that this is for bow hunting programs administered by the county. So they don't have to go down to 50 yards, right? That's a limit, but they can designate in any particular area where hunting will be allowed and where it won't. So there may be places where they only go, they may choose to maintain a safety zone of 100 yards or 75 yards. They just can't go smaller than 50. And
Thank you.
I feel like they have the expertise to manage a safe program.
Okay, that's a great clarification. And then on the elevated, how are we defining that?
So we did not quantify elevated, but we did clearly say that it has to be shooting with a downward trajectory, although I see Mr. Moriarty raised his hand, so let me make sure I didn't just misspeak.
Yeah, you did not misspeak. I would just say that you confirm that elevated position is not defined. I did speak with DNR about how they interpret the term elevated position and the term tree stand. First of all, tree stand is considered an elevated position that somehow incorporates a tree, essentially, was their wording. And with regards to elevated position, I had asked whether firing a bow from a ridge or a hilltop, for example, would be considered an elevated position. They said no, and they would consider that one would have to be elevated off the ground wherever they're standing or sitting. So it would be typically some sort of structure that lifts them off the ground, is how it's
Off the ground. Thank you.
interpreted, I suppose. Yeah. So there's no definition, but that's how it's interpreted elsewhere by DNR.
Off the ground. Thank you.
Ms. Ziegler?
Yeah, I was just going to say that the crop damage permit is something that you have to reapply for every year. You have to have specific shooters on your permit. You can't just get a permit and then do whatever you feel like for the rest of the year. When you take a deer, it has to have a number and you have to turn a ticket in to DNR. It's a pretty monitored program. So I do feel as though I put in the same amendment as Jessica Feldmark, great minds think alike. I really do think that this takes care of Senator Gazzoni's concern that somebody with a, azalea bushes getting eaten in a 2-acre garden thinks they can start shooting away. So that's and the thing about the elevated position, I did raise that, but there are a lot of cases where there might just be a farmed field. And so there is no tree to put a tree stand in, but people do have other methods of raising themselves up off the ground. So I was comfortable with that. Thank you.
And I just wanted to clarify, maybe for other people who had the same question, but when you are on your own property, let's say it's your own farm, you can shoot deer with bows and arrows at any distance from your own house, but it's the neighbors' houses that we're protecting with the 50 yards.
Right.
Correct?
Correct. So in the case that you have a neighbor's house that's within 150 yards of your property line, for example, let's say it's 70 yards away, there will be, I guess, an 80-yard section of your property that's within their safety zone. If you were hunting in that section, you would need the permission of the owner occupant of that building. And there is, yeah.
I think we did have a motion to move the amendment, correct? So could you please take the roll on the amendment?
Yes, Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazzoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb and Gazzoni,
Yes.
Delegate Hill,
Yes.
Delegate Taraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
The motion passes.
We have a motion on the bill.
As amended.
Second,
Take the roll.
Senator Lamb,
so I want to explain my vote. I do appreciate the tenacity of the sponsor and kind of working through this, coordinating with the county to get us additional information, and also to Delegate Feldmark for amendment as well. I know there was a lot of effort put into this. I know there's also a deer problem. I have heard a lot of concerns from constituents, and so it does give me pause. And so at this time, I'm a no on this bill.
Delegate Watson,
Yes.
Senator Gazoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb Gazoni,
Yes.
Delegate Hill,
Yes.
Delegate Taraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
The bill passes with the amendment.
Thank you. We are moving right along here. I'm going to hand the chair over to Senator Lamb for the rest of the meeting.
All right, thank you, Chair Watson. We have two bills remaining for discussion. The first one up is in the campaign finance category is Howard County 7-23. This is Delegate Peraza's bill on reports of donations and disbursements for the Columbia Council. The bill, I think, has been introduced by Delegate Peraza earlier. I don't think there are any amendments, correct?
There are amendments.
Okay. We'll go ahead
We can-
and
We
offer
can
your
resend
amendment.
them. Okay, the amendments are, the first one, we had a constituent who asked for us to put in a clause that said, this section applies notwithstanding the articles of incorporation, bylaws, rules, and any other governing documents of the village associations. I think that DLS did not think that was necessary, but didn't think it would be harmful and said that, and went ahead and drafted it. So it just assures some constituents that this is not going to be blocked by, I think most of our legislation would already do that, but this is a just in case. Should I tell you the second amendment, or do you want to move that amendment?
Let's move the amendments separately.
Okay.
So,
Move the amendment. So I'll move that amendment.
Second.
all right, any further discussion on the amendment? Hearing none, why don't we go ahead and call the roll?
Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb Gazoni,
Yes.
Delegate Hill,
Yes.
Delegate Taraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
Motion passes.
All right, thank you. Delegate
Okay,
Taraza, you have additional amendment.
I do, thank you. So the second amendment was just to change an or to an and. It was just a technical thing, because what the bill was drafted as that the villages have to make the information available either online or available if somebody asks for it, and this would do both.
Okay, you move the amendment?
Move the amendment.
Is there a
Second.
Okay, I think Delegate Feldmark seconded. Ms. Rivling, would you want to call the roll?
Senator Lamb,
Yes.
Delegate Watson,
Yes.
Senator Gazoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb Gazoni,
Yes.
Delegate Hill,
Yes.
Delegate Taraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
Motion passes.
Okay, great,
So
thanks.
I had a third one, and I think folks expressed concern about this one when I said it before. This one says a village community association has exclusive authority to determine whether a candidate has properly filed a report or donations and disbursements and may take office under paragraph 1 of the subsection. I think some were concerned that I was changing somehow the relationship between CA and the villages. I don't know if that concern still exists. I'm happy to just not move that amendment if there's concern about that.
I think you ought to move it and see how the vote goes.
Okay, move the amendment.
There's a
Second.
All right, seconded by Delegate Hill. Any discussion? Mr. Moriarty, you have your hand up, and then Senator Guzani.
Yeah, I think this is the perfect time for me to say this, that I've discussed with other people in our department. It is not any of our understanding that this amendment changes anything in relation to the village community association. It's more just kind of a reinforcing provision, I suppose, but it doesn't add any extra responsibilities in there.
Okay. It was a little hard to hear you at the beginning there, but were the members get the gist of that, or would you like, no? I see
I did
some
not.
shaking
Is it
heads.
just that it doesn't change? Sorry, I'm so sorry.
Right, yeah, it doesn't add any additional responsibilities, and it doesn't change anything. We understand this more as just like a reinforcing provision of their authority. It's not adding any additional responsibility.
Okay. Senator Guzani, you had your hand up earlier? No, you're good. Okay. Delegate Feldmar?
Just real briefly, thank you, Mr. Chair. I just want to confirm then, Mr. Moriarty, this only deals the exclusive authority that we're stating here that belongs to the village only pertains to determining whether or not this provision has been adequately met. Is that correct?
Yes.
Okay, thank you.
It's only in relation to whether this has been met.
I'm sorry, I couldn't, something was off with the audio. I couldn't make out what you said.
It's yes, essentially it's you're correct.
Okay. Any further questions on this amendment? Okay, seeing none, Ms. Rivlin, can you take the roll on this amendment?
Yes, Senator Lamb,
Yes.
Delegate Watson. Delegate Watson,
Sorry, yes.
Senator Guzoni,
Yes.
Senator Hester,
Yes.
Delegate Atterbury. Delegate Atterbury. Delegate Feldmark,
Yes.
Delegate Lamb and Guzoni,
Yes,
Delegate Hill,
Yes.
Delegate Terraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
The motion passes.
Okay.
Okay, thank you. Any
Mr. Chairman.
further amendments?
Yeah, thank you, Mr. Chairman. I have one further amendment that I did not introduce, but I heard from some, or I guess I heard from at least one of you, the concern about the villages legal action being taken against the villages. And so I have an amendment that said a person may not take any legal action against a village community association because the village community association refuses to allow a candidate to take office under paragraph 1 of the subsection. I don't know if there's an interest in that. I'd like to hear if there's, I had not planned on that, but I know that there was some concern expressed about that issue.
I guess similar to the last amendment, if there's interest in discussing that, someone should make the motion second, and then we can open it up for discussion. I see Delegate Feldmark, you have your hand up.
Thank you, Mr. Chair, and I'm sorry if this is getting into discussion before the motion, but I guess from my perspective, this raises a lot more questions for me, for sort of
Yeah.
late in the game. And to say no legal action for not seating, but what if someone was seated and someone thinks that's inappropriate? Like,
I agree.
I'd rather not start this now.
Thank you. I appreciate that input. Unless somebody else disagrees with that, I don't plan to move that.
Okay, doesn't look like there was a motion to move that forward. So any further amendments? Doug Atraza.
There's no further amendments. I just want to briefly discuss the bill.
Okay,
I
so
sent,
do you want to
I
move
know there
the,
had been some,
do you want to move the bill?
okay,
move the
move the
bill?
bill as amended.
Okay, is there a second?
Second.
All right. Discussion then. Doug Atraza.
So I know that there have been some folks who have expressed some legal concerns, some constitutional concerns. And I will assure everybody that I've worked on this extensively with the AG's office from the very beginning and would not have introduced this had I not believed this could stand up to constitutional scrutiny. What I said in the memo was that oftentimes we have an issue that's really important, something like gun control or cannabis. And we know that those things sometimes require constitutional scrutiny, and no attorney can tell you this will definitely pass constitutional scrutiny, because unless this exact case has passed before, it's really, and with the same court, there's really no way to know that. What we've done is we followed everything that was required in the test, and we built a legislative record, and I included that in the memo last night. And I guess it'd be hard for me to understand why someone wouldn't want to support a bill about transparency that that we believe could stand up to constitutional scrutiny. Even if you think there are those concerns and they could be raised, that's to be raised by an opponent of the bill. If we're concerned about transparency in these elections and the fact that it has over the years become apparent that there is an interest in putting money in our CA elections, I would also point out that CA is a very unique entity. And so that's why over the years, we've had lobbyists come in and say, don't apply this law or that law or the other law. It comes to my committee, so maybe others, well, I think somebody on the Senate side might be familiar, but on our side, it comes to my committee. So we get all the time CA's lobbyists say, Columbia is different. And so, and sometimes we agree with them and we take that out of, take them out of things that apply to HOA laws. So this is a very different entity. It's very different than other nonprofits. And I think it's a true concern that there's a similar community. While it doesn't have exactly the same status, there's certainly the similar in terms of the way it is a master plan community and not incorporated. And similar money flowed into that election. And they know that because of campaign finance reporting. And I think this is just about understanding what's happening so that our voters can make informed decisions. And I think we all know that's important when it comes to us. And I think that we can see that it's important when it comes to Columbia Association elections, regardless of exactly their status. We've all lived with Columbia for a very long time now. So I would hope that you would support me in this, and that's my comments. I'm happy to answer any questions.
So,
Mr. Chair, I have a question.
Go ahead, Senator Hester.
So, I mean, I really appreciate the sponsors trying to help me understand the components of this bill and how CA works. And I actually lived in the Thunderhill area for 10 years. So I was a loyal dues paying Columbia member. I guess I'm struggling with the state, the state oversight of something that is both small and large at the same time. It's small because I feel like we're really meddling in a homeowners, it's a homeowners association's business. It's large because it could be the second largest city in the state. And so all this has gotten me thinking about, like, why is Columbia not incorporated? And wouldn't that just solve so many of the rules that we're trying to enforce? And so that's, I'm just sharing this because I'm really kind of uncomfortable with both CA bills that are before us right now.
So I don't know if Jess wants to answer that as well. I think that the incorporation of Columbia has come up in the past, and it has been struck down over the years many times. If folks want to have that discussion, that's a discussion to have with all of Columbia. I don't think we can opine on that. But what I'll say is that when the Woodlands, which is a sister community of ours, and I sent information, well, I don't think I actually sent you that information. My apologies. When the Woodlands trying to incorporate, Howard Hughes created a PAC and put in $150,000+, and there were $300,000+ in the PAC to defeat incorporation. I'm not saying that it's a good idea or bad idea, but I certainly can see from some of the faces on here a thought that it's not a good idea. And there may be differences of opinions across Columbia, but I would say a couple of things about that. One, whether or not that's a good idea, I don't think it makes sense for us to wait for our constituents. There's money now in the in CA elections in a way that I think any of us who've run for CA board before, I don't think anybody's ever put in, you know, more than a couple $100. I never ran with any money. I don't know about you, Senator Gazzoni or Clarence, or Senator Lamb and Delegate Feldmark. And who else has been on the village board? I apologize if I'm missing anybody, but I don't think, so sorry. Of course you've been Delegate Wu. And you've been on the CA board. So I don't think any of us have put in, you know, more than a couple $100, if anything. And so I think the problem is real now, and that we shouldn't wait for that. And that if we did, and we don't have, the reason we know that $300,000 was put in to defeat a motion to a campaign to incorporate a city is because they had campaign finance reporting. So, and that doesn't mean you can't vote for or against it. It just means that you can be an informed voter and know what forces are for or against the incorporation. And I think that is something that we should be moving towards. And this moves us in a direction of that in terms of knowing what money was put into the elections. 55,000 was at least reportedly put into elections in the Woodlands in 2021. And I would worry about the same thing happening. And I think we shouldn't wait at this point.
Okay. I do want to be clear, you know, we're not intending to impugn Howard Hughes here. You know, I think the Woodlands was obviously a separate case, but we, you know, to the earlier point, you know, the money can be coming from anywhere, right?
Yes.
It's not just Howard Hughes. So
thank you, Senator Lamb. I appreciate that clarification, because to be honest with you, I'm more concerned about other entities involving themselves. I mean, we've seen across the country that small elections are the target of white supremacist groups and anti-CRT groups and others who are interested in starting out. And I know that CA has become a starting point, a stepping off point for, as I mentioned, all the people who have been on the village board or the CA board, sorry, Delegate Wu, but it's really become a stepping off point for higher office, and for us to leave those seats, to leave the voters, for people in those seats to not have the information they need to make informed decisions, I think is a concern. And I appreciate you saying that about Howard Hughes, because it's not about Howard Hughes, it's about anybody involved in that. And Howard Hughes at least has an interest in the community because they're part of developing Columbia, but somebody else might not.
I want to give other members of the delegation opportunity to ask questions or input. Other folks. Okay, this wasn't in self-interest to raise my own hand, but I do have some constitutionality concerns. I do, you know, broadly would support Columbia being a municipality. You know, obviously that's a different discussion, but, you know, to the fact that, you know, the constitutionality concerns are very real. I had a chance to speak with Sandy Brantley, our Attorney General assigned to the General Assembly, and talk through some of the legal input that she provided in those letters, she did cite the fact that there, would be references back to the legislative record, right? And the record that we're generating right now through this discussion and discourse is the legislative record. And I think it's important to note that, at least from my perspective, I have some concerns about the constitutionality and want to include that in the legislative record as well. The constitutionality problem is, I'll try to summarize it here that that Ms. Brantley brought up. The Supreme Court has ruled that contributions are a form of speech. Whether we like that or not, contributions are a form of speech, and speech is obviously a First Amendment right. So any imposition on contributions, which are speech, have to reach a high threshold for a, quote, significant government interest in order for courts to accept this impingement on the First Amendment. I think that there is a very weak case here that there's a significant government interest for a few reasons. One, Columbia Association, as much as we like to say that it's analogous to a municipal government, to a city government, it is not technically a city government. And this would be a very easy campaign finance bill if Columbia was actually a municipality, because we have, as a state, required reporting for municipal elections. There are formal elections. So it's hard to make the case here that there is significant governmental interest, because there's nothing wrong with contributing money to individuals that serve on boards. And so, two, the contributions are not illegal. Those things, it's not malfeasance to be able to make these contributions. And if there's a need to compromise on the First Amendment, to impinge on the First Amendment, that there has to be a very high threshold, of which I don't think this crosses, because there's not even anything formally recognized as illegal with this. It may be distasteful. I think, certainly there are concerns. I'm not sure that this bill actually tries to address the core root of those concerns. I also want to point out, when it comes to the constitutionality, the Attorney General also cites a California case where California law was passed to require nonprofit entities to report contributions to their board members above a threshold, so that law enforcement would be able to search for kind of illegal activities and such. In that case, Americans for Prosperity versus Bonta went all the way to the Supreme Court. The Supreme Court struck it down, in that they did not find, this was under Justice Roberts' ruling, did not find that it was narrowly tailored enough to an important government interest in that case. And that was for actual disclosure of malfeasance. In this case, there's nothing illegal here. I think it does set up a constitutionality concern, and Ms. Brantley did, to me, convey that her letters were intended to be a yellow light, or maybe even an orange light, not a green light to proceed. Certainly, if this were to proceed, they would have to defend it, but I think they have some concerns about the risk of whether it would pass constitutionality arguments. It's also precedent setting. Columbia Association, while it's a HOA, it's also a large kind of nonprofit. I'm concerned about how this would open the door potentially for other nonprofits, large and small, to have to disclose contributions to those who serve on their board. I think that brings up some concerns too with precedent. So let me pause there. I see Delga Terraza has her hand up. Go ahead.
Thank you for raising those concerns. I appreciate it. First, I would like to clarify that this is not subject to high scrutiny. This is subject to medium level scrutiny. One of the reasons that we didn't add, and I know that there are some who think that we would be getting closer to the problem, the supposed problem, or closer supposedly to the problem, wanted us to do independent expenditures, but we have no evidence on the independent expenditure side. And so that at this point might be subject to a higher level of scrutiny. So that's not part of this bill. However, if we have campaign finance reporting required, then we will be able to see whether there's other money flowing into, but we don't have any evidence of independent expenditures whatsoever at this point. And that, like I said, could be subject to a higher level of scrutiny, but this is under the law, a medium level of scrutiny. The other thing I would say is I talked extensively with the attorneys about this. I understand that yellow to orange. I think that's just about whether or not it can be taken to court. But my understanding, and I worked with DLS before we even got started on this to make sure that they were comfortable enough for us to move forward. But what I will say is I talked extensively with Sandy Brantley also about the nonprofit issue, because I know Senator Lamb was very concerned about that, and I would share those concerns. And nonprofits are very distinguishable from what we have here. The issue with nonprofits is about the nonprofits. You're donating to a nonprofit is a voluntary move. You can decide whether or not to do that. Unlike that, in Columbia Association, if you live on CA assessed properties, you are required to pay the assessment. It is part of your property, basically. And so that's the way that this is much more like a government. But my understanding from my conversation with her, and you certainly can talk to her separately again, is that this is very distinguishable from the nonprofit issue. And then the other issue about nothing illegal, well, there's nothing illegal about donating to us either, but we require campaign finance reporting for us. And so I think it's important that the issue is for people to know where the money's coming from so they can better evaluate those candidates. And that doesn't mean, I mean, I will tell you, there are people in Columbia said, oh, we should ban certain types of, whatever. I don't think we should ever get into banning those donations. The issue is for people to be informed about it. And maybe they like that particular, maybe they want somebody who's, I don't know, white supremacist to be in there, and that helps them decide that way. I would hope they don't. But from my perspective, it gives us informed voters, and informed voters are better voters. And that's how I think we all got here, is with informed voters. And, the last thing I'll say about that is I don't think because it's precedent setting, it's a bad idea. I'm not of the belief that we can't set precedent, but the good thing about it being precedent setting is there's no case law against this. And CA is a precedent setting entity. It really is, certainly is in Maryland. And there are very few like it across the country. So thank you.
Okay, thank you. Delegate Watson, has your hand up.
I'd like to call the vote on this bill.
Okay. The bill was probably moved and seconded earlier, so we can go ahead and call the roll. Ms. Ruebling?
Senator Lamb,
I'm a no on this, and for the reasons earlier. And I think we as legislators do have an important role in making sure that bills that we pass into law do pass constitutional muster. I understand that this could be defended in the courts, but to the extent that we have a responsibility making sure that our bills are constitutional, I think we have to take that first step and not just defer to either the executive branch or the judicial branch on this. So I'm a no on this.
Delegate Watson,
I am also a no on this, and I want to explain my vote by saying that, of course, I support informed voters. Of course, I support transparency in funding elections. But my understanding about Columbia Association is that the village boards can now make this requirement on their own for their own elections. I noted that there was not, the village boards were not unanimous in supporting this bill. There was one village board who did not support it. And the remaining village boards that did support it, I hope that they will take it upon themselves to create this kind of regulation within their own board. I would prefer that we go that way rather than have the state sort of step into this, this oversight responsibility for a homeowners association. And further, I do have some concern about Columbia Association bearing legal expenses related to this, if in fact it is taken to court. So for all those reasons, I really hope that the village boards regulate this themselves, especially after this discussion. And I appreciate Delegate Terrazza bringing it forward, talking about it. We've had a lot of time together to talk about it. I just don't think this is the way to go about it. So my vote is no.
Senator Guzzoni,
Yes.
Senator Hester,
Get some sleep.
Senator Hester,
She looks great. You look.
No, for many of the reasons identified by Delegate Watson and Senator Lamb, unfortunately, I'm a no at this point.
Delegate Atterbury,
Yes.
Delegate Feldmark,
Yes.
Delegate Lamb and Guzani,
Yes.
Delegate Hill,
Yes.
Delegate Terraza,
Yeah, thank you. I appreciate everybody's consideration of this. I think it's really important. I hope you'll consider it again in the future. And my vote is yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
The bill fails, lacking a majority in the Senate.
Okay, we have one bill remaining, and that is Delegate Feldmark's Bill 17-23. Delegate Feldmark, is there anything you would like to add or any amendments to the bill?
Thank you, Mr. Chair. So I don't have amendments. The original version of the bill that was posted was a draft that was still in review. There were some revisions made during that review, which I discussed last night. So the bill doesn't actually have amendments, but just to clarify, this is expanding voting rights for residential property owners or leaseholders, right? So I know there have been questions about the commercial property owner voting rights in Columbia villages. This would not change that at all. It doesn't, the bill does not take away any existing voting rights. It very clearly clarifies, this is one of the changes that was made in reviewing, that this is, setting a minimum for owners of a residential lot or leaseholders, residential leaseholders, as tenants, that each individual named on a deed or lease for those residential properties would have voting rights. So this is about expanding voting rights for residents who currently in most of the villages, only have one vote per household. I think for many of the reasons that we've discussed on the other bill, in terms of recognizing that that Columbia is not the typical homeowners association, right? We are talking about actual taxing authority, essentially. It may not be public tax, right? But it is an assessment based on our SDAT assessment, and the proportion of it is certainly unique compared to other homeowners associations. So I do believe this is an important step to democratize our institution. I think, unlike to the point that Delegate Watson made about the villages having it within their control to do this, they really practically do not. There have been attempts to change this before. The threshold is so high that it is practically impossible to do this. And I do think that it is right for the state to step in and make sure that this, what would be our second largest city, is a little more democratic for its residents. So with that, I will move the bill.
Second.
All right, it's been properly moved and seconded. Any further discussion? Delegate Terraza.
Yeah, I want to thank Delegate Feldmark for bringing this bill. I think democratizing.
You muted yourself.
Thank you. Did I say I thank Delegate Feldmark for doing this, and for, I don't know how much, when I muted myself. It's really important. I think democracy is really important. I think, as we talked about in the last bill and this bill, CA is a very unique structure, and maybe there's other conversations to be had about that. But anything we can do to move towards, from my perspective, transparency, but also democratizing the process is a good one.
Okay, thank you. Any other comments, questions? Okay, Ms. Rivlin, will you call the roll?
Senator Lamb,
I'm going to vote yes on this because I appreciate the sponsor's efforts and concerns. I don't see any constitutionality concerns with this, and so I'm comfortable voting yes on this.
Delegate Watson,
My vote is yes on this because I don't think there really is a way for the village boards to do this, to accomplish this. And hopefully, if we provide one vote per person, we will get more people involved in the CA elections and improve the situation with the CA board. And because village boards really can't accomplish this on their own is what is swinging my vote to say yes.
Senator Ghazzoni,
Yes.
Senator Hester. Senator Hester. Delegate Atterbury.
She was muted.
Yes, yes.
That was a yes from Senator Hester.
There was a yes from Delegate Atterbury. Can you call Senator Hester again?
Senator Hester,
I vote yes, given some of the comments that have been made, but just for the record, I'm uncomfortable in general with the state, stepping into this kind of thing. And I think it warrants a bigger conversation about the setup of Columbia.
Delegate Feldmark,
Yes.
Delegate Landon Ghazzoni,
Yes.
Delegate Hill,
I would have liked to have more conversation in the community. But it looks like it's going to pass anyway, so I will vote yes.
Delegate Terraza,
Yes.
Delegate Wu,
Yes.
Delegate Ziegler.
Yes.
The motion passes. Favorable.
Okay. Sounds good. That reaches the end of the agenda. Those bills that are moving forward, we will prepare a letter for the committee's consideration when the bills are dropped into the hopper on the House side. Seeing no further agenda items.
Senator
Yeah.
Lamb,
Go ahead.
we do want to mention to everyone that please watch your email for future meetings. They will be sporadic. We know that we do have one coming up with Senator Van Hollen. So we want to thank you for everyone's hard work. Senator Lamb and I have really appreciated everybody working together on all of these bills. And I think we've done good work. So pay attention to your emails for future meetings. Back over to you, Senator Lamb.
Nope, that's it. That's what I was going to say at the end. Just we have probably some informational meetings that are coming up. They're via Zoom, maybe one, probably not much more than that, maybe two. But otherwise, just pay attention to your emails, and we'll go from there. Take a motion to adjourn.
Move to adjourn.
Second.
All right. Okay. Thank